A very warm welcome, everyone, to the webinar at Walker Morris. This is the first time that I've personally used our new studio, so this is quite exciting, but simultaneously terrifying because it's new technology. We've all got used to being at home. We've now all managed to find our way into the office, so we're feeling pretty pleased with ourselves. The subject for today is the enigmatically titled "The Need to Connect in the Office versus the Right to Disconnect, How to Square the Circle." It naturally falls into two parts, which we're going to address. But I think to set the scene, I want to read a quote with some statistics. And this was a LinkedIn survey, and I will read it. Last year, in conjunction with the Mental Health Foundation, found that a loss of boundaries between home and work life and additional work-based pressures meant an average of 28 hours each month were worked in addition with those in the pandemic, and an additional 28 hours. So that immediately illustrates the issue that people are working longer, even if they're working in different places. So as we start to come back into the office and we start to connect, are things going to get better or worse? Will it become easier or harder to disconnect? And whose problem is it anyway? And to throw into the mix, certainly in the UK, we would have heard this morning, I was listening to the radio this morning on the business news, the government are pushing proposals to increase the ability for people to request flexible working, making it a day one right. A slightly different point, but it's in the same mix of disconnecting, flexibility in the office, hybrid working, all those sort of words. Now, to help us think this through today, I'm joined by two colleagues from Walker Morris in the room with me. Lucy Gordon, Director in the Employment team at Walker Morris. Dominic Mantle, Associate in the Employment team at Walker Morris. And I'm super pleased to be joined by Catherine O'Flynn from William Fry in Dublin. You'll notice that she's not in the room, but hopefully you can see her on the screen. Still too difficult to travel, illustrating the fact that we're in a slightly different world still. As many of you will know, William Fry is one of the leading commercial firms in Ireland, and indeed with a reach across way beyond Ireland with offices elsewhere. Catherine heads up the Employment and Benefits team at William Fry, and she's also the current chair of the Law Society's Employment and Equalities Committee in the Republic of Ireland. And I've specifically asked Catherine to join the event because of her experience and Ireland's experience on the right to disconnect. Their rules were introduced in April of this year. As many of you will know, Ireland and the UK has a shared heritage. It's very similar cultures, similar pressures, and actually quite a lot of similarity in terms of the common law-based legal system. So I think her insights will be really interesting, how they are grappling with it and what we can learn and how that will inform the discussion. In terms of practicalities, we're going to keep it interactive. I'm going to be talking to these people. If you've got questions and stuff, do ping those through. We'll do our best to answer them. If we can't deal with them today, we will get back to you. And there's also going to be a recording of this, so if colleagues can't make it and you feel it's of any use, you can pass that on to them as well. And to the extent anyone's interested, my name is Andrew Raymond. I'm one of the partners in the Employment team at Walker Morris. To get things started, perhaps I could ask you, Dominic, perhaps you could give us a brief overview of the key legal and practical issues about getting people back into the office.
Of course, thanks, Andrew. So I think it's fair to say it's a very different picture, different sectors, and it's worth mentioning as well. Many people have been working from the office throughout the pandemic, for example, key workers, so not everyone's in the same boat. For those of us who have been largely working at home rather than the office throughout the pandemic, there's recently been a shift in that respect. with the end of the government's guidance to work at home where possible. That stopped in the middle of July. Many of us are now returning to the office at least part of the time. So we have a sort of new term feeling almost, going back to school days, to use that analogy.
Yeah.
It's worth being aware that the government's guidance on working from home could change again. Let's hope not, but it could. And that was alluded to in the COVID winter plan the government put out. I believe it was last week. So in terms of reasons why employers are keen to have employees back in the office, to mention but a few, you have things like creativity and collaboration being much easier to achieve when you have people able to see each other in person.
Yeah.
They can be more spontaneous with things. Also, particularly considering more junior employees, things like development of soft skills and supervision of those employees will be much easier to achieve where you are in person together.
It's interesting. And how are employers going about achieving getting people back in? What's happening at the moment, and what legal issues are they grappling with?
So, in terms of having those discussions with employees about returning to the office, there's no one approach which is the correct way to do it. Some employers might want to put in place a written policy. Others might want to keep it less formal than just having long conversations. But what we would advise would be to do it in a way that means you're consulting with employees, perhaps asking them to come back to work on a gradual basis, to get people used to it more slowly. Do it in a way that's sort of flexible and sensitive to different people's home life and different people's circumstances.
And have there been any legal challenges or complaints yet, or is it what's happening in the sort of courts and tribunals?
Sure. Well, I think one legal issue to be aware of is to make sure that you don't just adopt a one-size-fits-all approach. Could be something which risks discrimination claims potentially. If one employee has a certain sort of protected characteristic, which means they're less able to come into the office as it might be required by their employer, then that could be risking claims being brought. In terms of issues which have come with all the tribunals related to working from the office during the pandemic, a number of employees have taken cases through the tribunals on grounds of asserting that they have the right to stay away from work on health and safety grounds. They say, a number of them, or they have said, they have been in serious and imminent risk of danger. And under the Employment Rights Act, you are entitled in certain circumstances to stay away from your workplace on those grounds. There's been a mixed response to those claims in the tribunals. The main message takeaways for employers though is that if you do have a health and safety policy in place, you have taken precautions, that it's going to be unlikely that employees will be able to be successful in those claims on those grounds. Although it's worth again keeping an eye on how things turn out over the winter with COVID, because there's certainly potential for employees to be successful on those grounds. So it's worth carrying those health and safety concerns.
Yeah, if you get the health and safety homework done, then you're in a reasonable place. Okay, that's great. So thank you for that. And Lucy, from your perspective, what issues are you seeing with clients, and how are they sort of grappling with things?
Yeah, we're seeing a complete range of queries coming through at the moment. So one particular area has been around vaccination status and employers wanting to know whether they can ask employees about their status in order to judge situations in a workplace.
Mm-hmm.
From a data protection perspective, the ICO has said it may be possible to ask for that information, provided you've done the relevant risk assessments. But I think what we would say is for employers, before they rush into going down that route, is to really think about what they're going to do with that information. If an employee says they aren't vaccinated and they don't want to be vaccinated, where's the employer going to take that? There could again be risk of unfair dismissal or discrimination claims based on what the employer does with that information. Another area where we've had a lot of queries has been around the proposals which have subsequently not been adopted by the government around COVID passports for getting into nightclubs and large-scale venues. Those haven't been adopted in England, although the government is advising that businesses put those arrangements in place, but they are coming into effect in Scotland and Wales from October.
Yep.
So again, a bit of a divergence across the country.
Yeah.
And really what employers are grappling with there is the fact that they have to ask, or they are advised to ask customers about their vaccination status or whether they've recently had COVID and therefore have immunity, but the same rules don't apply to their own employees. So it's really kind of deciding whether there is a need to ask employees for that issue. So yeah, quite a range of queries.
And quite a moving target as well to try and
exactly as the rules change.
Yeah. And have you or your clients seen any sort of complaints or groups making noise, issues, whatever language you want to call it, about these issues and how it's shaking out?
Yeah, so there's particularly a lot of people may have seen in the media, Pregnant Then Screwed, a group that act on behalf of women who are pregnant or have young children. They've been reporting a significant increase in resignations from women, perhaps with childcare responsibilities, who have discovered this sort of new flexibility throughout the pandemic, and some employers are being inflexible about their return to the workplace. So they're basically, voicing their discontent with their feet, and they're moving to employers who are more flexible with those types of requirements. Equally, they're sort of raising the profile of pregnant employees who may still be nervous or cautious about returning to the workplace, and actually how employers can help communicate with employees to allay any of those concerns or to put alternative measures in place. Yeah.
Okay, so it's interesting. Again, it's a sort of developing area. And Catherine, perhaps over to you. How has it been over the water in the Republic of Ireland? What are you experiencing over there?
First of all, thank you so much for having me today. I'm really happy to join this webinar. It's great and such an interesting topic, and very timely for us in Ireland, because just this week the government policy allowed businesses to have people back into the office. As Dom said, of course, there have been lots of people in lots of jobs working away throughout the pandemic. But for those who've been out of the office since back in March, this is the first time this week that a lot of those people will come back into the office. Now, the government does say it has to be on a phased basis, and you do have to have a business requirement for coming in to the workplace. So it's not a blanket return to the workplace by any stretch of the imagination. So it's kind of a cautious and careful return, I guess, on a staggered basis. So maintaining things like social distancing, as you say, doing your health and safety homework, checking your risk assessments, ventilation, occupancy levels, make sure you've had a deep cleanse, all those good things. So this is a phased return, with the plan being then that October 22nd is the next big day when all restrictions will be lifted and people will be allowed to return to work at that point in time. That's the current plan anyway. As John said, it's open to change, always in line with public health. So yes, been a busy week in terms of getting people back into the workplace and the lead up to that. And then the other kind of issues that we've been looking at are very similar to yourselves in terms of, a lot of employers, in fact, the majority, are looking at some kind of a hybrid model going forward. So, the main banks in Ireland have said they're going to have a hybrid policy. The government is certainly encouraging that remote work remains part of the future of work. So in terms of helping clients with those hybrid policies, similar issues to what you've discussed. highlighting potential issues for discrimination, the data protection privacy issues where you have people working in different locations, proximity bias, we need to be very careful that presenteeism doesn't creep back in. And also a key message I always feel is to make sure that the managers who are really grappling with questions from employees are well trained to know how to deal with those kind of questions and what the plan is. Yeah,
so it's sort of reassuring that you got the same challenges.
absolutely.
It's slightly different time scale, a slightly different emphasis, but it's the same sort of issues.
Yes.
That's brilliant. So thank you for that, Catherine. I wonder whether we can now shift to the sort of the right to disconnect topic and then attempt to bring things back together towards the end. So, Lucy, we've all seen sort of headlines of articles talking about the right to disconnect in the UK, and I'm hoping they're not the only person in the room who's slightly scratching their head, thinking, what does that mean in the UK? What is all this talk? What does it mean at the moment in the UK?
Well, at the moment, it's a sort of pipe dream. We don't have any rule at the moment about disconnecting from the workplace. So we have sort of usual safeguards in place under the working time regulations for people to have adequate breaks and rest periods, but we don't have what is typically coined a right to disconnect. So a right to disconnect from electronic devices in particular periods. And I think what we've seen throughout the pandemic, as you referred to before, people have been working longer hours. There was very little to do during lockdown, so it's the option of watching television or perhaps doing a little bit of extra work. And for many people, that has led to a degree of burnout and working very, very long hours. The flip side is that some other people might have found the ability, for example, to work later in the evening or very early in the morning a benefit in terms of actually fitting their working day around other commitments like homeschooling, and it could have produced a degree of flexibility that wasn't there previously. I think what everyone's concerned about there is really from the mental health agenda in terms of making sure that people don't just work consistently and that we do have some boundaries back. So one of the proposals that's come forward, particularly from the Prospect Union, who represent engineers, scientists, those in the tech industry, they are recommending that there is a legislative right to disconnect that would apply to employers who employ 50 or more employees, and that it would essentially be an obligation to negotiate every year with employees about core periods when people could have the right to disconnect. That proposal is being supported by Labour, and there is a suggestion that that type of right could be included in the employment bill, which we're expecting towards the end of this year. But we have to wait and see. We don't know yet whether that's going to be included.
Okay, so thank you. So the phrases I'm picking up there are pipe dream, proposal, potential.
Exactly. Okay. And it's very clear that anything that is suggested would need to take account of business requirements. You know, we still need to operate in that fashion.
Thank you. Well, it's a perfect introduction to Catherine, in the sense of, Catherine, I know from our discussions and what I've read that you guys are ahead of us, and actually you have implemented some rules to do with the right to connect. I suppose perhaps you could just talk us through what was the journey to introducing those.
Sure, yeah. So there's been discussion about it for a couple of years. Certainly, you know, with the technology advances generally pre-COVID, and that was mostly led by the bankers trade union in particular, calling for it. And then we also have to transpose the EU work-life balance directive by middle of next year. So this would kind of fall in with a suite of measures in that regard as well. So this year then, I guess in the midst of the pandemic and everything that had thrown up in terms of people, this always on culture that Lucy was talking about, the Minister for Enterprise, Trade and Employment asked the Workplace Relations Commission in Ireland to draft a code of practice on the right to disconnect. and they sought submissions from various parties. So the Irish Congress of Trade Union were involved, an employers' representative body was involved, and the Workplace Relations Commission came up then with the Code of Practice, and that was published on the 1st of April of this year. So it is in effect, but I would say it is a code of practice, so it's not legislation. So it's about best practice and guidance for both employees and employers, and it's intended to supplement existing legislation. So, for example, the Organisation of Working Time Act, which is the legislation that makes employers record hours and breaks, and gives employees entitlements to annual leave, and so on. Also, it is meant to supplement health and safety at work legislation, because obviously this is about well-being. It's about creating a safe place of work and assisting with mental health at work, and also the terms of employment legislation that requires employers give employees certain details within certain periods of time to include their normal working hours. So it kind of complements that existing legislation. So if an employee brings a claim under existing legislation, they can refer to any non-compliance with this code of practice in the course of that case. So although they couldn't bring a standalone claim under the code of practice, it can be admissible in evidence. So basically it's all about protecting the boundaries between work and leisure.
And okay, so it's interesting. So it sounds like, you know, we've got similar pieces of legislation like the working time regulations and our Employment Rights Act, etc. So you've got similar building blocks, but the additional thing that you guys have that we don't is this code of practice about disconnecting. So I suppose the obvious question is, what does the code say in headline level? What guidance does it give us?
I mean, it's very practical, and I would recommend, you know, if people are interested in this area and want to sort of preempt issues that might be coming down the track, is to have a read of the code of practice. It's very easy to read. And there's lots of tips that we can talk about, but in terms of the actual main messages of the code, there are 3 main messages, I would say. The first is that it sets out to give employees the right not to be routinely required to work outside of their normal hours.
Okay.
The second thing then is that employees can't be penalised if they refuse to work outside of their normal working hours. And then the third main message is that both employers and employees have a duty to respect each other's right to disconnect. So they're the main messages on which the code is built, I guess. So from that, you can take it that there's not an absolute ban on contact outside of hours, whether that be telephone or email or whatever. So it's not an absolute ban, because that is recognised in the code of practice as not sustainable or practical. So the code does recognise that there will be instances where you need to have contact outside of normal working hours. And it gives a few examples of things like, you know, if you have to cover for a sick colleague, or if there's an emergency or customer requirements. But it does say that they should be the exception rather than the norm.
Okay.
Yeah.
And have they? It's great. There's lots of wonderful sort of lawyer type words in there.
Yeah.
Like routinely, exceptional. Have they? I guess with it being so recent, it hasn't been tested in the courts yet, but. Is there any guidance or wisdom on what those words will mean in practice, or what clients are doing?
Yeah, so it hasn't been tested yet. I mean, there are good delays in the Workplace Relations Commission as it is, so we haven't seen any claims come yet. Just on that topic, I guess we've only really had one constructive dismissal claim really that touched on someone who requested the right to work remotely, and it was refused, but it was quite COVID-19 specific really. So not a lot of case law to go on yet, but what employers are doing, I mean, when it was published, there was a fair bit of publicity, given that Ireland was one of the first countries to come out with such a code of practice. And I guess a lot of neighbouring countries were kind of looking at it enviably and with great interest. There was some criticism, of course, from opposition parties, for example, that it was a code of practice as opposed to a law, that it didn't go far enough. But broadly speaking, it was welcomed, because what it does do is start this debate, you know, and putting the idea in people's heads. So from our client's perspective, then what we were advising them to do would be to draft up a policy, because that is what the code of practice suggests that employers do. And in fact, it does give some template wordings for policies and that. So it's quite helpful. So, broadly speaking, the policy should talk about the right to switch off, flexibility for occasional legitimate contact outside of normal working hours. It should give guidance for employees who work with different time zones. And importantly, it should have a method for raising concerns, which we would suggest to clients refer to your existing grievance policy. Seems to make sense, And then, it talks about training being important. Train your managers so they understand how to deal with requests or issues under this code. It talks about culture needing to change for this really to be embedded, which I think is, a really valid point. If we're all completely addicted to our iPhones and checking our inboxes, we'll probably just need to look at our own practices, and then that'll flow down in terms of the culture of an organization. And also things like, even outside of sort of email, it talks about meetings. Think about, do I need to invite that person to a meeting? Are they going to have an active involvement? Because I guess we can all find some days our days are just, our calendar is full of meetings. And do we really need to be at all of them? And then some other nice practical messages, like for emails, you might want to include an email footer that it suits me to send this email at this time, but you're not expected to respond immediately. And you can use sort of automatic functions that your email provider provides. There's all kinds of good things there. It talks about thinking about the tone and sense of urgency in your communication. So if I send a team member something on a Sunday night, make sure the tone is right. If I absolutely have to send it on a Sunday night, that they know they don't need to read it or action it until their normal working hours. So as I said, it's definitely worth a read. And it is there to sort of complement the existing legislation. And there are some interesting pointers in it that, as I said, I think the good thing is it certainly starts a debate flowing about this whole right to disconnect.
And it seems very interesting, doesn't it, that you haven't gone down, well, the country hasn't gone down the route of sort of mandatory turn the servers off, which I think some of the other continental European countries are heading towards, aren't they?
Yeah. And as I said, there was some criticism from some corners that it wasn't legislation, but it is a code of practice that can be admissible in evidence. And in terms of having a policy, do the way we always talk to our clients about the must-have policies and then the nice-to-have policies. And we would say to clients, this is close to a must-have policy, really, to be honest. Both, in terms of keeping yourself safe from any potential complaints and claims, but also in the sense of creating the right culture in your workplace. You will have seen, as much as we've seen, huge attrition rates, coming out of the pandemic, people talking about this great resignation. So we have to make sure that our workplaces are places that people want to join, and employees, all employees, but I kind of do think that employees here maybe joining the workforce for the first time have expectations that perhaps we didn't have when we joined the workforce back when. I won't say when. They're much more sensible. So I think for all of those reasons, it's important to get on board with this topic.
That's excellent. Thank you for that, and we'll come back. But maybe to turn that back to Lucy. So I suppose, having heard that, what do you think, I suppose, what's your crystal ball going to say about how that might shake out in the UK? What can we learn from that?
I think, as we sort of touched upon before, and as Catherine's explained, it's likely to be a similar outcome in the UK. If there is anything that comes out of these discussions, it's unlikely to be very prescriptive in terms of legislative, like you say, shutting the servers off, not contacting people between particular hours, because it's just not workable for business. And particularly, in light of the current situation, we want to keep the country open as well for working with different businesses, particularly those in the US, and actually working, like you've said, Catherine, at different time zones will assist with that. So my crystal ball, I think, it's going to be something that's slightly more flexible for employers to implement. But either way, whether it's legislative or not, whether we get anything along those lines, it's quite clear that, as Catherine says, prudent employers at the moment need to start having these conversations with their employees, because otherwise people do just vote with their feet. And actually employers putting something in place voluntarily will give them more control over designing something that works both for them and their employees.
Yeah. And again, it's always coming back to different part of the discussion, but it's the same point, isn't it? It's got to be, you can't have one size fits all.
Exactly.
The policy will be different for different employers and different industries, and maybe different groups of employees within the business. Just want to ask another question back to Catherine. As I think I mentioned at the beginning, in the UK, they're looking to extend the right to request, keyword being request, flexible working to what I'd call a day one right. At the moment, you have to wait 6 months, I think it is. Where are things in the Republic of Ireland on that?
So we don't actually have a legislation that allows employees request the right to work flexibly. But going back to the EU Work-Life Balance Directive, which we have to have transposed by next year, one of the things that we do need to have legislation to that effect. And the Minister for Enterprise, Trade and Employment has said that legislation will be coming out towards the end of this year. So currently in the legislation anyway, the only time you can request to move to a more flexible pattern is on the return from parental leave. Is the only place it's mentioned in our acts, which is interesting. Now, that's not to say that a prudent employer won't have their own policy, but as it stands currently, they're not required to have it by law. So we're, I guess, waiting to see what that looks like. And if I was to get out my crystal ball, I would imagine, it's hard to know, but I'd imagine it would be sort of similar to the part-time workers legislation, which is an employee has the right to request it, but the employer isn't obliged to grant it, but they must consider it carefully. I imagine it'll be somewhat similar to that.
Yeah, I think they're still proposing to keep, we have 8 statutory, he says holding up 5 fingers, 8 statutory reasons as to why you can refuse, but again, provided they're also not discriminatory in their own basis, and obviously including indirect. Okay, well look, I found that fascinating. Let me try and draw together what I've heard and learned. It seems to me that whilst many businesses are grappling with the getting back into the office, that's only part of their considerations. It should be. They need to be recognising that getting people back into the office, whether it's September, October, November, January, some businesses are taking a longer term. They certainly need to be thinking about, what is work going to be looking like, and taking into account the right to disconnect, clearly in the Republic of Ireland, but for the reasons we've discussed. I think a sensible employer will be having that in their plans, because either a code or legislation is coming, but certainly the market seems to be saying if flexibility, balance, whatever language you want to call it, isn't given, people will not be happy, and you're going to have a recruitment and retention problem. So I think it certainly needs to be factored in there. And I would also, what I'm hearing here is that there needs to be a consistent and joined up approach. And I think what I see that as is there needs to be a clear policy on what it is and are the expectations for work. In the office, out of the office, in the evening, at the weekends, flexibility, part-time. There needs to be clarity, because I think if people aren't given clarity, they will be banging on your door, to the extent that anyone has a door in an open plan office anymore. But they will be demanding it. And if you don't meet that, I think, again, we're going to end up with recruitment and retention problems. And if there isn't clarity and consistency, that rapidly leads into discrimination problems, either as a matter of unfairness or as a matter of illegal discrimination. And again, I think we have similar rules, don't we, Catherine, in terms of sex, race, disability, etc. Remembering the concept of indirect discrimination. I think that also needs to be what people are saying here. It needs to be fed into your own retention and recruitment policies. It's no point putting loads of effort into seeking to recruit people if actually it might be quicker and cheaper to retain people. Having a sensible policy on hybrid working and such like is probably a lot easier than speaking to lots of recruitment agents. No disrespect to them, and if they're listening in. I think we also need to be mindful of making sure that these things are tied together in terms of equality and diversity policies. Most sensible employers are having a big push on that at the moment. Make sure that your policies on disconnect, flexibility, hybrid are consistent with that messaging. Make sure that your departments within your business are talking to each other to make sure that it's consistent and certainly not contradictory, because that clearly would be very awkward in a tribunal if you have two opposing witnesses. We've all seen it happen. I think another thing I was talking to a client yesterday, and they're again grappling with trying to create a flexible workforce, because as Lucy was saying, some people might choose to work in the evening. Well, then all of a sudden they might need IT support in the evening. So you're then demanding or asking people to be on call or something in the evening. That's great, because that's meeting a flexible work request over there. How are you then measuring that work, and how are you paying for that work? Because you're rapidly into tricky issues like you had with almost sleep-in shifts and carers in the MenCap case, those sort of things. That has an implication for minimum wage, working time regs, and almost certainly the equivalent in the Republic, I would imagine. So we need to think about how are we then going to measure that time. It comes back to that question of what is work. So that's certainly going to need to be happening. I think it was you, Catherine, was essentially saying you also need to make sure your managers, when they're faced with questions, are trained and equipped to know how to deal with the requests. Because if you have different teams and different managers dealing with it in a different way, you're certainly going to have unhappiness. You may well have unfairness, and you may well have discrimination. So the managers need to be equipped. And I think it's also the managers need to be bold and live out those values, which I know sounds a bit woolly, but I think it is true actually, which is easier said than done. I mean, you've got clients shouting at you. But those are the issues we need to deal with, I think. I liked what, again, forgive me, I can't remember whether it was Catherine or Lucy or both of you or Dom, about those electronic aids, in terms of email footers. We all know roughly how to send a delay on an email. Maybe we all need to be encouraging that with our workforces. And it's partly a flexible thing. That's partly a disconnect thing. It's partly a hybrid thing. But those sort of words about, I'm sending it this time because I choose to, you don't have to reply. Catherine, you were talking about the example of Sunday night. Again, many of us do that. We're thinking, I've got 2 hours, I can just plan my week. In planning my week, I shouldn't ruin Dom's week. So sorry, Dom. Those sort of things, I think we could be weaving that in. That's a take-home message for me. I can be talking to my IT team to say, how do I do that? It's a training need. And I think also, the final message I'm receiving from Dom's part is, as we get people back to work, into the office, should I call it, because we have been working at home, again, it's do your health and safety homework, isn't it? In terms of what is your workforce? What is your workplace? That risk assessment, as we all know, is a continual thing. But again, check it. There's a lot of homework for all of us to do, I think, isn't it? To assess our own policies. What do we have policies? If so, are they consistent? Are they sensible? Are they legal? You know, are they empowering, protecting, all those sort of things? So I think it's a fascinating topic. I think it's a topic which is going to keep rumbling on. We haven't got time to deal with any questions which have come in today, but we will reply to those separately. If people do have other questions, lovely to hear from people on that. Also, people's views and experiences, actually, because I think this is a continuing conversation. This is not a we know best type thing at all. We're all learning together. So I think it only remains for me to give a special thank you to Catherine for beaming in from the Republic of Ireland. I think your insight has been incredibly useful as we grapple on that side of things like right to disconnect. Thank you to Lucy and Dom, and thank you for everyone else for tuning in. And we hope to see you all, whether we see you physically or remotely, at some time soon. So thank you and have a good day.